Chapter 21, Fraudulent General Assignments, SS 316, Voluntary Assignments. To discuss the general phases of the law regulating voluntary assignments made by debtors for the benefit of creditors would require a volume, and is foreign to our purposes when, however, as is frequently the case, these assignments are mere contrivances called into being to hinder, delay, or defraud creditors, and, from their surroundings, or upon their face, contravene the provisions of the Statute 13 Alis. C5. Creditors may attack and annul them. The principles of the law regulating this branch of the subject are legitimately within the line of our discussion, and they will, upon investigation, be found to constitute a prolific source of legal controversy. It seems remarkable that the instrument under which an insolvent surrenders up his depleted estate to his creditors should so frequently be itself tainted with the poison of fraud. It may be observed at the outset that to constitute a general assignment there must be an element of trust, and the conveyance must be voluntary. The property in possession of the assignee is not in custodia legis, for the reason that the assignee is not an officer of the court, but is a trustee bound to account according to the terms of the instrument, and his authority depends upon the validity of the assignment, and is not conferred by the court. The assignee derives all his power from the assignment, which is both the guide and measure of his duty. Beyond that or outside of its terms he is powerless and without authority. The control of the court over his actions is limited in the same way, and can only be exercised to compel his performance of the stipulated and defined trust, and protect the rights which flow from it. He distributes the proceeds of the estate placed in his care according to the dictation and under the sole guidance of the assignment, and the statutory provisions merely regulate and guard his exercise of an authority derived from the will of the assignor. The courts, therefore, cannot direct him to pay a debt of the assignor, or give it preference in violation of the terms of the assignment and the rights of other creditors under it. To hold the contrary would be to put the court in the place of the assignor, and assert a right to modify the terms of the assignment, after it had taken effect, against the will of its maker, and to the injury of those protected by it. The assignee is merely the representative of the debtor and must be governed by the express terms of his trust. The parties cannot change the terms of the instrument, or withdraw the property from the jurisdiction of the court, or absolve the assignee from its control. Nor can the assignor substitute a successor if the assignee resigns. The new appointment must be made by the court. SS 316A. Property transferred by assignment. The discussion has already embraced the authorities declaring what assets creditors may reach by bill or other proceeding, as creditors are frequently forced to accept upon their claims whatever the assignee is able to realize from the property. It is important to know what estate is acquired by such a transfer. Every interest to which the personal representatives of a deceased person could succeed may pass by a properly framed assignment. The assignee may acquire title to a claim for conversion, may gain a right to recover in replevin, and to sue a common carrier for the loss of goods. He takes monies deposited in bank and lands which belonged to the assignor. In Warner v. Jaffray, the court said, the assignment was a mere voluntary conveyance, and can have no greater effect, so far as passing title to the property assigned, than any other conveyance. In New York State by statute the assignee is clothed with power to assail fraudulent alienations of property. Rights of action for personal torts which die with the person are not assignable, as for instance damages for an assault and battery. So the title to trust property does not pass, nor does property in transit, nor a wife's dower right, nor exempt property. The assignment, it may be here recalled, takes effect from the time of its delivery. SS 317. Word void construed. The distinction between void and voidable acts will be defined and discussed at length presently. It will be shown that the term void is constantly interpreted to mean nothing more than voidable, and that this construction is especially true as applied to voluntary assignments, though the statute in characterizing assignments constantly uses the term void as to creditors. It is obvious that nothing more is intended than inoperative or voidable, or, as was observed by Chief Justice Shaw, such conveyance is not absolutely void, but voidable only by creditors. It is the distinguishing characteristic of a void acto that it is incapable of ratification, but an assignment which is fraudulent upon its face is capable of confirmation by creditors, and is good between the parties. Hence it is not logically speaking void. SS 318. Delay and hindrance. Mr. Burrell says, the term delay has an obvious reference to time, and hindrance to the interposition of obstacles in the way of a creditor. But, to a certain extent, the one involves and includes the other, in point of fact, and is actually applied by the courts. They are always taken together. The The following are prominent instances in which assignments have been declared void on the ground of hindrance and delay: where the time of sale or of collection by the assignee, 0, or of finally closing the trust has been, by the terms of the assignment, unreasonably or indefinitely postponed; where the assignee has been expressly authorized to sell at retail, and on credit, or on credit simply, where the assignment has been made with a view to prevent a sacrifice of the property; where the proceeds of the assigned property have been directed to be used in defending all suits which might be brought by creditors to recover their debts, and where creditors who should sue have been expressly debarred from the benefit of the assignment, or postponed until all the other creditors are paid. All these were instances of delaying and hindering creditors in the prosecution of their remedies in the strict sense of the terms used in the statute. In the famous Sprague litigation, it is said that a debtor has no right to postpone or put in peril the claims of his creditors without their consent, and that a conveyance which attempts so to do, or which is executed for the purpose of depriving creditors of their right to enforce their just claims against the property of their debtor, by placing it beyond their reach or control for an unlimited, indefinite, or uncertain period, is in conscience, as well as in law, fraudulent. SS 319. Intent affecting assignments. It is clear, however, says Mr. Burrell, from the language of the English statute of 13 Elizabeth, that its provisions were directed exclusively against conveyances made with an actual intent, on the part of debtors, to hinder, delay, or defraud creditors, as distinguished from the mere effect or operation of such conveyances. The expressions in the preamble, devised and contrived, to the end, purpose, and intent to delay, etc., leave no room for doubt on this point. Hence, it has sometimes been very expressively designated as the statute against fraudulent intents and alienation. It will be presently shown that the learned writer has stated the rule too broadly. For a fraudulent intent is often imputed by the law in cases where the assignur's motives were undoubtedly honest. Generally speaking, the subject of inquiry in these cases is the intent of the assignur or debtor, though there is authority tending to establish the rule that the fraudulent purpose sufficient to defeat the instrument must be participated in by the assignee or beneficiary. The testimony of both the assignur and assignee upon the question of intent is proper, recognizing the general rule, elsewhere discussed, that a voluntary conveyance or gift may be annulled at the instigation of creditors, without proof of an absolute fraudulent intent on the part of the donee. It would seem to follow by analogy that the cases which hold that proof of the fraudulent intent of the debtor or assignur is sufficient establish the more logical and salutary rule. In a case which arose in New York, it was expressly decided that an assignment by a debtor, with the intent to hinder or defraud creditors, may be avoided although the assignees were free from all imputation of participation in the fraudulent design, and were themselves bona fide creditors of the assignur. In Lewes v. Wilkinson, Earl J. said, an innocent assignee may not be permitted to act under a fraudulent assignment. It may be true that in a particular case an honest assignee may undo all the fraudulent acts of the assignur preceding and attending the assignment and the preparation of the schedules under it. Yet, if the assignment was made by the assignur with the fraudulent intent condemned by the statute, the assignment may be set aside at the suit of judgment creditors, and all powers of the assignee, however honest he may be, taken away, in assailing a voluntary assignment for the benefit of creditors. It is important only to establish the fraudulent intent of the assignur, and when that has been established, the assignment may be set aside, and creditors may then pursue their remedies and procure satisfaction of their judgments as if the assignment had not been made. SS 320. Fraud must relate to instrument itself. Where it is sought to annul a fraudulent transfer, the evidence must ascertain and establish the assignur's intent at the time of the execution of the instrument. If the assignment was valid in its creation, having been honestly and properly executed and delivered, no subsequent illegal acts, either of omission or commission, can in any manner invalidate it. The subsequent acts should, however, be considered, as they may reflect light back upon the original intent, and help to characterize and discern it more correctly. It may be observed that neither conveyances without consideration, nor other frauds committed by a failing debtor prior to a general assignment for the benefit of his creditors, will operate to make it void as matter of law. These are circumstances which may be taken into consideration by a court and jury, if nearly contemporaneous, but are not conclusive of a fraudulent intent to render the assignment invalid. When good on its face, the fact of a fraudulent intent in making it must be legitimately found from evidence that will fairly support the finding, and it must also be an intent to commit a fraud on creditors by making the assignment. and not by some entirely independent act which might and probably would have been done precisely as it was, had no assignment been made or contemplated. Proof of an intentional omission from the schedules of assigned property, of items of valuable property, is sufficient to establish a fraudulent intent. Referring to this subject, Finch, J., said, "The intentional omission, calculated to deceive and to lull into slumber and inactivity the interest and diligence of the creditor, would plainly argue a fraudulent purpose. Not so, however. If shown to have been unintentional and the result of accident or oversight, it would be hard to find any schedules absolutely perfect, or any debtor who could inventory every item of his property with strict accuracy. Room must be allowed for honest mistake, and possibly even for careless and thoughtless error. But, where the omission cannot thus be explained or excused, the inference of a fraudulent intent must follow. Room must be allowed for honest mistake, and possibly even for careless and thoughtless error. But, where the omission cannot thus be explained or excused, the inference of a fraudulent intent must follow. The motive to prevent creditors from gaining a preference will of course not avoid the assignment. It may be here remarked that if an assignment is made in the form and manner provided by law, and duly recorded so as to pass all the property of the assignor, it is difficult to see how the motive existing in the assignor's mind can affect its validity. If in morals the motive be a bad one, yet in law it produces no forbidden result. In so far as it hinders or delays creditors, it is a lawful hindrance and delay, and cannot be held fraudulent. The commission of a lawful act is not made unlawful by the fact that it proceeded from a malicious motive. SS 321. Good faith. The term good faith, if interpreted to mean sincerity or honesty of purpose, can scarcely be applied in that sense to assignments, for these instruments are often annulled from considerations of public policy in cases where nothing was more foreign to the intention of the debtor than a dishonest design. The usual presumption of good faith incident to acts and transactions generally appertains to an assignment, and it will be upheld where the language of the instrument justifies a construction which will support it. The usual presumption of good faith incident to acts and transactions generally appertains to an assignment, and it will be upheld where the language of the instrument justifies a construction which will support it. SS 322. Void on its face. An assignment for the benefit of creditors may undoubtedly contain a clause so plainly indicative of the fraudulent intent pointed out by the statute, or recognized by the policy of the law, as to carry its death wound upon its face. An instance of this might be a gratuitous provision out of the assigned property for the insolvent assignor or his family. The New York cases clearly establish the rule that where the assignment shows upon its face that it must necessarily have the effect of hindering and defrauding the creditors of the assignor, it is conclusive evidence of a fraudulent intent, and may be avoided. The actual motive and belief of the debtor in such cases is immaterial, where it is apparent from the face of the instrument itself that it is a conveyance to the use of the assignor. It is the duty of the court trying the cause to tell the jury as a matter of law that the conveyance is fraudulent as against creditors. In the case of Dunham v. Waterman, Mr. Justice Selden, referring to the opinion of the Court of Errors in Cunningham v. Freeborn, remarked, "It follows from the reasoning of Mr. Justice Nelson, which I regard as unanswerable, that wherever an assignment contains provisions which are calculated per se to hinder, delay, or defraud creditors, although the fraud must be passed upon as a question of fact, it nevertheless becomes the duty of the court to set aside the finding, if in opposition to the plain inference to be drawn from the face of the instrument, a party must in all cases be held to have intended that which is the necessary consequence of his acts." SS 323. Constructive frauds defined by Story. By constructive frauds, observes Mr. Justice Story, are meant such acts or contracts as, although not originating in any actual evil design or contrivance to perpetrate a positive fraud or injury upon other persons, are yet, by their tendency to deceive or mislead other persons, or to violate private or public confidence, or to impair or injure the public interests, deemed equally reprehensible with positive fraud, and therefore are prohibited by law, as within the same reason and mischief as acts and contracts done malo and imo. Again, the commentator says, another class of constructive frauds upon the rights, interests, or duties of third persons embraces all those agreements and other acts of parties which operate directly or virtually to delay, defraud, or deceive creditors. Of course, we do not here speak of cases of express and intentional fraud upon creditors, but of such as virtually and indirectly operates the same mischief by abusing their confidence, misleading their judgment, or secretly undermining their interest. It is difficult, in many cases of this sort, to separate the ingredients which belong to positive and intentional fraud from those of a mere constructive nature, which the law pronounces fraudulent upon principles of public policy. Indeed, they are often found mixed up in the same transaction. SS 324. Assignments contravening statutes. We may state as a general rule that an assignment which contravenes the provisions of a statute, or vests the assignee with a discretion contrary to the terms of an express provision of law, and authorizes him to effect sales of the assigned property in a manner not permitted by the statute, will be declared void. This principle is learnedly discussed in a case recently decided in the Supreme Court of the United States. The assignment provided as follows: the party of the second part shall take possession of all and singular the property and effects hereby assigned, and sell and dispose of the same, either at public or private sale, to such person or persons, for such prices and on such terms and conditions, either for cash or upon credit, as in his judgment may appear best and most for the interest of the parties concerned, and convert the same into money. It will be observed that the assignment did not by its terms prevent the assignee in the administration of his trust from following the directions of the statute in all particulars. Counsel contended that the assignment was valid because the discretion given the assignee by the assignment left him at liberty to follow the law, and because even if the assignment required him to administer the trust in a manner different from that prescribed by the law, only such directions as conflicted with the law would be void, and the assignment itself would remain valid. The Supreme Court of the United States, however, did not adopt this view, but followed the construction given to the assignment law of Arkansas by the Supreme Court of that state in Raleigh v. Griffith, to the effect that such an assignment was void as to creditors, and held that the construction put upon the law by the highest court of the state where the assignment was made was binding on the courts of the United States. The substance of the opinion in Raleigh v. Griffith is that the statute is disregarded in the deed of assignment, the assignee being authorized to sell at private or public sale, and for cash or on credit. The assignee was vested with a discretion to prolong the closing of the trust for an indefinite period, the legislature having deemed it expedient, as a matter of public policy, to require an assignee for the benefit of creditors to sell the property within a specified time and prescribed manner. The dissenting creditors are not barred by a deed made in direct contravention of a plain provision of the statute. The provisions of the statute are mandatory and not directory, and it follows, in the end, which vests the assignee with a discretion contrary to the mandates of the statute, and in effect authorizes him to sell the property conveyed thereby in a method not permitted by the statute, must be void, for contracts and conveyances in contravention of the terms or policy of a statute will not be sanctioned. SS 325. Transfer to prevent sacrifice of property. In German insurance bank v. Nunes, the material part of the deed read, that whereas the said first party is indebted to sundry persons in various sums, amounting in the aggregate to about $38,000, and is the owner of a large amount of assets, estimated to be worth more than $50,000, and whereas the said first party is unable to convert his said assets into money fast enough to discharge his said indebtedness as it matures, and is desirous that the same shall not be sacrificed, but so managed and disposed of that they will realize their fair value at as little cost as possible, and satisfy his creditors in full, and leave a residue for him, etc. The court said that it was the intention which controlled, and that this could not be better determined than from the language of the convey. The deed declared that it was made to prevent the property and to the debtor. It also avowed that the assets were largely in excess of the liabilities, and it would seem to follow that the primary object of the deed was not to secure creditors, but on the contrary to obstruct them in the enforcement of their legal remedies in order that the debtor might be benefited. The deed was declared to be fraudulent upon its face and was set aside. SS 326. Reservations. Exempt property. A favorite ground of attacking assignments made by debtors for the benefit of creditors is that a reservation has been made in the debtor's interest, or that there has not been a complete surrender of the debtor's dominion and control over the property. The question comes up in various phases. Davis, P.J., observes, it is well settled that the reservation of the least pecuniary character by the assignor or his family, and any device to cover up the property for the benefit of the assignor, or secure to him directly or indirectly any benefit, is fraudulent, and has always received the condemnation of the courts. The debtor who makes an assignment of this character must devote all his property to the payment of his debts, except such as is by law exempt from execution. the withholding of any considerable sum of money at the time of making an assignment from the assignee must, we think, in some form be explained, otherwise it is sufficient to establish a fraudulent intent. An assignment is void which does not include the assignor's real estate. A reservation of $800 worth of property renders an assignment void on its face, and an assignment is invalid if the debtor prefers his landlord's claim for rent of a dwelling house with intent to secure occupation for himself and family subsequent to the assignment without further payment. We have already shown that according to the weight of the best authority, a conveyance of a debtor's exempt property cannot be annulled as fraudulent. The same principle appertains in the law regulating fraudulent voluntary assignments reserving property exempt by statute. The assignment is not rendered void, for the reason that creditors are not hindered or delayed by the reservation of that which they have no right to touch. This is an exception to the rule clearly deducible from the cases that no debtor can, in an assignment, make a reservation at the expense of his creditors of any part of his income or property for his own benefit, nor can he stipulate for any advantage either to himself or family. Another reservation must be considered. SS 327, reserving surplus, where a debtor assigned all his property in trust to pay certain specified creditors, and then, without making provision for other creditors, to reconvey the residue of the property to the debtor. The instrument was declared fraudulent upon its face. The court held that it could not be made effectual by showing that there was, as matter of fact, no surplus resulting to the debtor after the preferred creditors were paid. Bronson, J. observed, the parties contemplated a surplus and provided for it, and they are not now at liberty to say that this was a mere form which meant nothing. And although it should ultimately turn out that there is no surplus, still the illegal purpose which destroys the deed is plainly written on the face of the instrument, and there is no way of getting rid of it. The Supreme Court of Nebraska, however, refused to follow this doctrine and considered that such a reservation was partial and only incidental. It merely stipulated for that which, had it been omitted, the law would have implied and required to be done. So in Hubler v. Waterman, the court observed, the reversionary clause is mere surplusage, for it would have been implied if it had not been expressed. The principle set forth in these latter cases certainly embodies the more logical rule. There is, however, an obvious distinction in these cases. In Griffin v. Barney, the surplus was to revert before all the creditors were paid, which was palpably fraudulent, while in the other cases the surplus contemplated was that remaining after all the creditors had been satisfied. Of course, the law will not permit a debtor in failing circumstances to convey all his property to trustees, with a view to exempt it from execution for an indefinite time, to authorize them to hold it against creditors until the profits pay all charges, expenses, and debts, and then to reconvey it or permit it to revert to the original owner. Property cannot be thus withdrawn from the operation of the law in its due course against the consent of existing creditors. SS 328. Releases exacted in assignments. Assignments exacting releases from creditors are looked upon with great disfavor by the courts. The law seems to be settled that assignments will be declared fraudulent and void if creditors are preferred on condition of their subsequently executing releases of their respective demands. The reason is obvious. It is a clear attempt on the part of the debtor to coerce his creditors to accede to his terms, and a withholding of his property from them unless they do so exceed. As was observed in Hislop v. Clark, it does not actually give a preference, but is, in effect, an attempt on the part of the debtors to place their property out of the reach of their creditors, and to retain the power to give such preference at some future period, if they can keep it locked up in this way in the hands of the trustees, and set their creditors at defiance for 3 months. They may do so for 3 years, or for any indefinite period. The right of giving preferences cannot be so exercised as to secure to the debtor the future control of the assigned property or its proceeds, as continuing the business in another's name. It has been considered competent for a debtor in failing circumstances to make an assignment for the benefit of creditors, providing that accommodation creditors shall be paid first. Secondly, those creditors who had executed a conditional release should receive 50%. And thirdly, the residue of the creditors should be paid. The whole estate was by this instrument devoted to the payment of the debts. It was considered that in no sense could it be said that an agreement by a debtor with a creditor to prefer him for 1/2 of his demand in an assignment, on condition or in consideration that the balance should be released, was a fraud upon those who refused to become parties to the contract. These cases certainly go to the verge in upholding an assignment of this character, and where it is apparent from the face of the deed, or as a moral certainty, that nothing will be left to the non-assenting creditors, the court will annul the assignment, SS 329, preferring claims in which a seigneur is partner rights of survivor. It was contended by counsel in Welsh v. Britain that if an insolvent person made an assignment for creditors and preferred a debt due another firm, one member of which was also a member of the assigning firm, this constituted such a reservation to one of the assignors as would avoid the assignment. The case of Caser v. Havenrich was cited, but the court said that it could not be said to establish so broad a principle. There a preference was given to one Lowenthal, and one of the assigning firm was an equal partner with Lowenthal in the preferred claim. This was held to be a secret trust for the benefit of that member of the firm and to invalidate the assignment. The fact of secrecy was also given prominence. On the other hand, the case of Fanshawe v. Lane asserts the absolute right of an assigning firm to prefer such debts. The Supreme Court of Texas followed this latter case. We may here state that the insolvent cannot delegate to the assignee the power to give preferences at his discretion. A special partner cannot be preferred for the amount of his investment. And where a limited partnership becomes insolvent, its assets are a special fund for the payment of its debts except those due to the special partner. A surviving partner may make a general assignment of the firm assets, Mr. Justice Harlan said. While the surviving partner is under a legal obligation to account to the personal representative of a deceased partner, the latter has no such lien upon joint assets as would prevent the former from disposing of them for the purpose of closing up the partnership affairs. He has a standing in court only through the equitable right which his intestate had, as between himself and the surviving partner, to have the joint property applied in good faith for the liquidation of the joint liabilities. As with the concurrence of all of the partners, the joint property could have been sold or assigned for the benefit of preferred creditors of the firm. The surviving partner, there being no statute forbidding it, could make the same disposition of it. The right to do so grows out of his duty, from his relations to the property, to administer the affairs of the firm so as to close up its business without unreasonable delay, and his authority to make such a preference, the local law not forbidding it, cannot, upon principle, be less than that which an individual debtor has in the case of his own creditors. It necessarily results that the giving of preference to certain partnership creditors was not an unauthorized exertion of power by Moors, the surviving partner. It necessarily results that the giving of preference to certain partnership creditors was not an unauthorized exertion of power by Moors, the surviving partner. SS 330, authorizing trustee to continue business. It may be observed that an assignment drawn precisely as it ought to be will not undertake to speak to the assignee in regard to his duties under the trust. These duties, unless the creditors themselves direct otherwise, are simply to convert the estate and pay the debts in the order and with the preferences indicated in the instrument. There are numerous cases reported in which assignments and trust for the benefit of creditors have been sustained, although they contain provisions for the continuance of the business of the assignor, either by himself or by his trustee. It will be found upon examination that in many of these cases, the business authorized to be carried on by the assignment was merely ancillary to winding up the debtor's affairs, and that the authority was given with the view of more effectually promoting the interests of the creditors. In cases where the authority is given chiefly for the benefit of the debtor, or where it is intended or calculated to hinder and delay creditors for an unreasonable period in the collection of their debts, it renders the deed fraudulent and void. SS 331, illustrations and authorities. Cases relating to this class of assignments are numerous. In Owen v. Body, the assignment, which was to trustees for the benefit of creditors, giving preferences, contained provisions investing the trustees with power to carry on the trade of the debtor, and for that purpose to lay out money in payment of rent and keeping up the stock in trade. The deed was adjudged void as being an instrument to which creditors could not reasonably be expected to assent. Lord Wensleydale, in giving his opinion in the House of Lords in the case of Wheatcroft v. Hickman, referring to this deed, said that the provisions contained in it allowing the effects of the debtor, which ought to have been divided equally amongst his creditors, to be put in peril by being employed in trade, prevented it from being a fair deed and good against creditors. In American Exchange Bank v. Inlows, the deed contained a provision empowering the trustee at his discretion to sell the property conveyed gradually, in the manner and on the terms in which, in the course of their business, the assignors had sold and disposed of their merchandise. For that reason the deed was adjudged void. Mason, J., said, without adverting to other objectionable, if not fatal, provisions in this deed, the one to which we have just referred is sufficient, in the judgment of this court, to render the deed null and void as against creditors. It simply seeks, through the instrumentality of a trustee, to provide for carrying on the business of the concern in the same manner in which it had been before conducted, and for an indefinite period, free of all control or interference on the part of creditors. Surely if such a provision in a deed is not calculated to hinder and delay creditors, we are at a loss to know what could have such an effect. Short of a conveyance and trust for the benefit of the grantor himself, a debtor cannot thus postpone his creditors to an indefinite period without their assent. A conveyance which thus attempts to deprive creditors of their just rights to enforce their claims against the property of their debtor, by placing it beyond their control for an uncertain and indefinite period, must be regarded in conscience and law as a fraud. In a later case in the same state, an assignment and trust for the benefit of creditors, authorizing the trustee to carry on and conduct the business for such time as in his judgment it shall be beneficial to so do, or to sell all the goods and stock in trade at such times, in such manner, and for such prices as he may deem proper, was adjudged void as against creditors. The court said, "It is obvious. The certain effect of this clause would be to hinder and delay creditors, and as against them such provision renders the deed utterly void. It is an attempt on the part of the debtor to place his property, for an uncertain and indefinite period, beyond the reach of his creditors, and to make their rights in a great measure dependent upon the uncontrolled discretion of a trustee of the debtor's own selection. The law will tolerate no such attempt, but treats the act as a fraud upon creditors, and the instrument of conveyance is simply void as against them. The law will tolerate no such attempt, but treats the act as a fraud upon creditors, and the instrument of conveyance is simply void as against them. SS 332. Delay, sales upon credit. An insolvent debtor cannot deprive his creditors of their right to have his property converted into money without delay. He can make an assignment with preferences, but he cannot authorize his assignee to sell on credit. No delay is permitted other than such as is reasonably necessary to secure the application of the property to the payment of his debt. In Dunn M.V. Waterman, Selden, J., following the reasoning of Nelson, J., and Cunningham v. Freeborn, said that wherever an assignment contains provisions which are calculated per se to hinder, delay, or defraud creditors, although the fraud must be passed upon as a question of fact, it nevertheless becomes the duty of the court to set aside the finding, if in opposition to the plain inference to be drawn from the face of the instrument, a party must in all cases be held to have intended that which is the necessary consequence of his acts. It follows that when this objectionable feature is embodied in the face of the assignment, the court itself will stamp it as fraudulent. In Buse v. Shaughnessy, the insolvent directed that the times, places, and terms of selling the property shall be agreed on by the trustee and the majority in interest of the first and second class creditors, and that if they did not agree, then 2/3 of all of the creditors should direct such times, places, and terms. The court said there seemed to be but one question to consider, and that turned entirely upon the construction to be placed upon the words terms of selling, whether these words in the deed of trust embraced the power to sell upon credit. Continuing, it was said that the courts generally held that deeds of assignment, giving authority to the assignee to sell upon credit, were fraudulent and void as to creditors not assenting thereto. And especially was this the case where the deeds made preferences between creditors. In New York, this general rule is fully recognized. The case of Kellogg v. Slauson, at first reading, would seem to be a departure from the rule, but upon a more careful consideration it will be found to be consistent with it. The assignees in that case were authorized to sell the property on such terms as in their judgment might be best for the parties concerned, and convert the same into money. The court, in upholding the assignment, said that this discretion must be exercised within legal limits. In Brigham v. Tillinghast, the case of Kellogg v. Slauson is referred to, and the court says that the words convert the same into money limited the disposition of the property to sales for cash, and that such was the purport of the ruling in that case. The same rule is reiterated in Rapoli v. Stewart. The assignment held to be valid in the case of Sumner v. Hicks contained language similar to that found in Kellogg v. Slauson, and indeed the closing words of the objectionable provision were precisely the same, viz., and convert the same into money. The inference from these cases is that if these last words had been omitted, the assignments would have been held void as authorizing sales upon credit. The word term signifies, among other things, a limit, a boundary. If we say the power of sale is granted without limit, without boundary, it can be exercised to an unlimited extent and without bounds. In the case of Buse v. Shaughnessy, and there was no restriction whatever upon the power of sale granted to the trustees and a fixed proportion of the creditors. They were authorized to sell upon such terms as they might deem proper, And this power had no limits, no bounds. This broad grant certainly would necessarily embrace the power to sell upon credit, SS 333, in Wisconsin. In the case of Hutchinson v. Lord, where the assignment empowered the assignee to sell in such manner and upon such terms and for such prices as to him shall seem advisable, it was held that this language gave power to sell upon credit, which would necessarily operate to hinder and delay creditors, and rendered the assignment fraudulent and void. In the case of Keep v. Sanderson, although the objectionable words were exactly those found in Kellogg v. Slauson, yet the court held that they conferred an authority to sell upon credit, and thus avoided the whole assignment. In Woodburn v. Mosher, the authority to the assignees was to convert the property into money within convenient time as to them shall seem meet. It was held that the assignment was void upon its face. In Keep v. Sanderson, it was decided that a clause in an assignment authorizing the assignee to sell and dispose of the assigned property upon such terms and conditions as in his judgment may appear best and most to the interest of the parties concerned, was authority to sell on credit, and that it was void as to creditors, in accordance with the decision on the former appeal, SS 334, exempting assignee from liability. Another subterfuge of insolvent debtors must be noticed. In DeWolf v. Sprague MFG, Co. The deed contained a clause which provided that in case the same are thus run by him or otherwise, he shall not be liable personally for the expenses or losses arising therefrom, but the same shall be chargeable to the trust fund vested in him. This was held in connection with the right to run the mills and print works, to furnish additional evidence of the fraudulent purpose for which the assignment was executed. A failing debtor cannot be permitted to put at hazard the trust fund which justly belongs to his creditors by authorizing the trustee to manage it without due prudence and caution. This question was before the New York Court of Appeals in Litchfield v. White. In that case, the assignment contained a clause by which it was mutually agreed between the parties to it that the assignee should not be held liable or accountable for any loss that might result to the trust property or the proceeds of it, unless the same should happen by reason of the gross negligence or willful misfeasance of the assignee. The assignment was adjudged void. Chief Justice Ruggles said, "A failing debtor by an assignment puts his property where it cannot be reached by ordinary legal process. He puts it into the hands of a trustee of his own selection, often his particular friend, sometimes a man to whom the creditors would not have been willing to confide such a trust. The debtor has an interest in the application of the trust funds to the payment of his debts, but the creditors have usually a far greater interest therein, and that interest depends in many cases on the competency and diligence of the assignee. The debtor cannot be permitted, by creating a trust for his creditors, to place his property where it cannot be reached by ordinary legal remedy, and at the same time exempt the trustee from his proper responsibility to his creditors. The debtor cannot be permitted, by creating a trust for his creditors, to place his property where it cannot be reached by ordinary legal remedy, and at the same time exempt the trustee from his proper responsibility to his creditors. SS 335, providing for counsel fees. The question of the right of the assignor to provide for or interfere in the matter of the assignee's counsel fees has been before the courts in various forms. In Heacock v. Duran, the assignee was a lawyer, and by the provisions of the assignment was to be entitled to a reasonable and lawful compensation or commission for his own services, both as assignee as aforesaid, and as the lawyer, attorney, solicitor, and counsel in the premises. The assignment was annulled on the theory that the power given to charge counsel fees tended so directly to the impairment of the fund and the injury of creditors that it was impossible to offer a valid reason in its support. The provision places the assignee in two inconsistent positions. This question was before the New York Court of Appeals in Nichols v. McEwen, and the court held that such a clause was fraudulent in its character and would vitiate the assignment. Roosevelt, J. observed that to sanction such a clause would be establishing a practice pregnant in many cases with the most mischievous consequences. Denio, J. says that an insolvent debtor has no right to create such an expensive agency for the conversion of his property into money and distributing it among his creditors. Besides being wrong in principle, it is calculated to lead to obvious abuses. It is no objection, however, to the instrument that provision is made for the payment of a reasonable attorney's fee for the examination of the facts and for advice and services in drawing up the assignment and securing it to be properly acknowledged and placed on record. But at this point the control of the assignor ceases. SS 336. Authority to compromise. The authority given to the assignees to compromise or compound any claim by taking a part for the whole, when they shall deem it expedient so to do, was considered by the New York Supreme Court not to expressly authorize or require an illegal act to be done. And the court refused to vitiate the assignment, and where the instrument authorized the assignee to compound choses in action, taking a part for the whole when he shall deem it expedient, the assignment was sustained. This clause was held to vest no arbitrary power in the assignee to compromise where such action was neither necessary nor proper, but merely to confer the discretion which the law recognizes to compound doubtful and dangerous debts in cases where the safety and interest of the fund demanded such action. It confers upon the assignee, said Finch, J., no unlawful or arbitrary power, and takes away from the creditors no just protection. On the other hand, the power given in the assignment to the assignee to compromise with creditors is held to restrain the creditors until the attempt to compromise is made. Thus they would be hindered, and a delay even for a single day would be fatal to the assignment, and whether the delay was directed by the instrument or justified by its provisions, or made necessary in the execution of its provisions, made no difference. SS 337. Fraud of assignee. The fiduciary character of his position precludes the assignee from taking any advantage of his influence as such, or from using, for purposes of personal gain or profit, any information acquired while acting in that capacity. Every agreement having such an object in view, made with the assignors, or with any of the creditors, especially if not approved by and communicated to all the parties in interest, is looked upon by the courts with great suspicion and distrust, and if tainted with the slightest evidence of fraud, concealment, or misconduct on the part of the assignee and its procurement, will be set aside as inequitable and unjust, and he will not be permitted to reap any personal advantage from it. An assignment honestly made for a lawful purpose cannot be defeated by proof that the assignee abused his trust, misappropriated the property, or acted dishonestly in its disposal, where the assignee is guilty of neglect or misfeasance. The creditor feeling aggrieved should apply to the court for a compulsory accounting, or seek his removal, and secure the appointment of a new trustee or assignee. Brown, J., said, in Olney v. Tanner, if an assignment is legally complete and perfect, and is intended to devote, and does devote, all the debtor's property to the payment of his debts, it cannot be invalidated through the subsequent remissness or inefficiency of the assignee. Creditors have ample remedy against the assignee for his misconduct, if any, and they should be held to these remedies, rather than be allowed to subvert the assignment on the claim that such remissness is an evidence of original fraudulent intent. On the other hand, if the assignment is set aside as fraudulent, the acts of the assignee, performed in good faith in the execution of the trust, will not be disturbed, whether the assignment be fraudulent in fact or constructively so. The assignee will not be held to account for the property or its proceeds which have been paid out by him in good faith. SS 338. Ignorance or incompetency of assignee as badge of fraud. The selection of an incompetent assignee is regarded in the law as a badge of fraud. Blindness in the assignee is considered an indicium of fraud on the part of the assignor who selects him. So, choosing an insolvent assignee is prima facie evidence of an intent to defraud, as is the selection of an assignee unfit to attend to business by reason of a lingering disease. It was with much doubt and hesitation that entire latitude in the selection of the trustee or assignee was confided to the debtor, and the insolvent having the choice of his own assignee, without consultation with or consent of his creditors, must see to it that he appoints a person competent to protect the rights of all parties interested under the assignment. If it appears that the selection of an incompetent assignee was made in order to allow the assignor to control the administration of the estate, then the assignment will be avoided, because such an intent would be a fraud upon creditors. Where the assignee, however, is selected without any improper motive, and proves incompetent, he may be removed upon a proper application, and a suitable person substituted by the court to carry out the trust. The words misconduct and incompetency, as used in the New York statute relating to the removal of an assignee, are construed to have no technical meaning, but were intended to embrace all the reasons for which an assignee ought to be removed. SS 339. Transfers inuring as assignments. Preferences in the absence of a bankrupt act are usually upheld, though avoided by the statutory system prevailing in some parts of the Union. A curious policy exists upon this subject in some of the states. Thus in Alabama it is said to be a settled proposition of law that a mortgage or deed of trust which conveys substantially all the debtor's property for the security of one or more particular creditors to the exclusion of others, the intention of which is to give a preference or priority of payment to the former, operates as a general assignment under the statute, and inures to the benefit of all the creditors equally. In Illinois, the surrender by an insolvent of dominion over his entire estate, with intent to evade the operation of the Assignment Act, and to create preferences, whether made by one or more instruments, operates as an assignment under the Act, the benefit of which can be claimed by any unpreferred creditor. In New York, however, it was held that a specific assignment of property by a debtor for the benefit of one or a portion of his creditors did not come within the provisions of the Assignment Act of that state, and was not void by reason of its not being executed in compliance with the provisions of the Assignment Act. SS 340. Assets exceeding liabilities. The question often arises as to what persons are entitled to make assignments, where it is clear that the assets are largely in excess of the liabilities of the debtor. It may raise a presumption of an intent to hinder and delay creditors in the collection of their just demands, and amount to a prima facie case of fraud. In the Missouri Court of Appeals, an assignment which, after reciting that the assets amounted to 3 times the liabilities, clothed the trustees with discretionary power to carry on the business of the firm for such time as the trustees shall deem for the best interest of the creditors, and necessary for the purpose of preventing shrinkage and loss, and of closing out and liquidating the same to the best advantage, was declared voidable as tending to hinder, delay, and defraud creditors. It is sometimes contended that, as assignments for the benefit of creditors are generally made by embarrassed and insolvent debtors, such dispositions of property can only be made by that class of persons. This doctrine, said Comstock, J., has no foundation in principle or authority. These assignments are in their nature simply trusts for the payment of debts. The power to create such trusts is certainly not peculiar to insolvent men. On the contrary, it is a power more unquestionably possessed by men who are entirely solvent. This right of disposition, on general principles of law and justice, was never doubtful except in case of a debtor's inability to meet his engagements. In that condition, the claims of creditors are in justice paramount, and the debtor's power to dispose of his estate, even for their benefit, was not established without a struggle. In short, it was the insolvency rather than the solvency of a debtor which suggested the doubt in regard to the right of putting the whole or any part of his property in trust for the benefit of creditors, as gathered from the authorities. The vital question in these cases is whether the transfer is honestly made with the sole intention of applying the property in satisfaction of the creditor's demands, or whether it is merely a scheme or contrivance to place the debtor's estate, for a time, beyond the reach of the creditor's remedies, prevent a sacrifice of the property, secure the payment of the creditor's claims, and ultimately realize a surplus to the assignor. In the latter case, it should clearly be regarded as a plan devised to hinder and delay creditors. Resort by a solvent man to the methods devised for insolvents is justly calculated to arrest attention and excite the most searching inquiry as to hidden motives. SS 341. Assignments to prevent preference. According to the doctrines of the common law, the validity of an assignment cannot be assailed simply because its effect is to prevent a party from obtaining, by judgment and execution, a priority and preference over other creditors. Temporary interference with particular creditors in the prosecution of their claims by the ordinary legal remedies is a necessary and unavoidable incident to a just and lawful act, which, however, in no respect impairs the validity of the transaction. The rule of equity requires the equal and rateable distribution of the debtor's property for the benefit of all his creditors. It would be strange indeed if the debtor, by making a disposition of his property with the design to effectuate the application of this rule, should be adjudged guilty of hindering and delaying his creditors. This precise question arose in Pickstock v. Lister. In that case, a debtor, being sued, made an assignment by deed of all his effects, for the equal benefit of his credit, the jury having been instructed that they must find the deed void if made with the intent to defeat the plaintiff in his execution, returned a verdict in his favor, but the verdict was set aside upon the ground that the jury were misdirected. Lord Ellenborough held that the assignment was to be referred to an act of duty rather than of fraud. When no purpose of fraud is proved, the act arises out of a discharge of the moral duties attached to his character of debtor, to make the fund available for the whole body of creditors. It is not the debtor who breaks in upon the rights of the parties by this assignment, but the creditor who breaks in upon them by proceeding in his suit. I see no fraud. The deed was for the fair purpose of equal distribution. In the same case, Bailey, J., said, "It seems to me that this conveyance, so far from being fraudulent, was the most honest act the party could do." He felt that he had not sufficient to satisfy all his debts, and he proposed to distribute his property in liquidation of them, This was not acceded to, for the plaintiff endeavored by legal process to obtain his whole debt, the obtaining of which would have swept away the property from the rest of the creditors if the assignment has been fairly and legally made, and creditors obtain a benefit from it. Their rights cannot be divested by proof of any stratagem practiced by the assignor to prevent attachments till this object could be secured, if no attachments were issued. Even fraud practiced by the debtors to defeat such process would give the creditor no lien upon the property, notwithstanding the grossest dishonesty of this kind. It would remain as it was, and so long as it continued the property of the debtors, unaffected by any attachments. No fraudulent conduct, calculated to impose upon a creditor and keep him at bay, would disqualify the debtor from making a valid assignment under the statute for the benefit of creditors generally. Fraud or misrepresentation on the part of the assignor, entering into or affecting the debt of a particular creditor, will not be sufficient to annul a general assignment in favor of creditors. Jacks v. Greenwood constitutes a possible exception to the rule above stated. A judgment had been entered against a firm by default. They secured a stay of proceedings upon pretense of a defense to the action, which they failed to show, and upon an assurance given by their attorney that no assignment would be made. Meanwhile, a preferential assignment was filed, and the judgment creditors were prevented from realizing anything upon execution. The assignment was, upon this state of facts, adjudged to be made to hinder and delay the creditors in the collection of their debt. SS 342. Threatening to make assignment. Threatening to make an assignment seems to constitute no ground for provisional relief by attachment in New York, provided the threat is not to make a fraudulent assignment. An unlawful coercion of a creditor, says Fullerton, J., cannot be predicated of the declaration of an intention by a debtor to do what the law sanctions as right and proper. On the other hand, there are cases tending to support the view that a debtor cannot use the power he possesses of assigning his property preferentially to intimidate creditors into abstaining from pressing the remedies allowed by law to collect debts, without being chargeable with intent to defraud creditors. In Gashery v. Apple, the court observed, the law allows a debtor to assign his property to pay his debts, and even to make preferences, but compels him to make his selection without any conditions for personal gain to himself. Thus he cannot, by an assignment, hold out a hope of an extra share of his assets, or a fear of loss of any participation therein, as a means to induce a creditor to abandon all or any part of his claim, or to forbear pursuing his legal remedies therefore. This certainly embodies the safer rule. SS 343. Construction of assignments. In construing the provisions of a general assignment, we are to be governed by the rules applicable to ordinary conveyances. Preferential assignments are not to be encouraged. The law tolerates rather than approves such instruments, and they can only be supported when they make a full and unconditional surrender of the property to the payment of debts. In Reed v. Worthington, in construing a general assignment, the court said, there are 3 general rules of interpretation, which, applied to this case, show that the intent on the face of the instrument was honest to creditors. Firstly, that the general intent of the parties is to govern. Secondly, that the leaning of all constructions should be in favor of supporting, and not overthrowing, an instrument. And thirdly, that fraud is not to be presumed, and assignments are subject to no different rules. Courts are therefore under no obligation to be astute to destroy them, and an unreasonable construction should not be given to the language used in the assignment to render it void. The scope of the assignment is to be gathered from the whole instrument, and where 2 constructions are possible, that is to be chosen which upholds and does not destroy the instrument. A court, said Finch, J., may wrestle, if need be, with unwilling words to find the truth or preserve a right which is endangered. It must be remembered that if a general clause be followed by special words which accord with the general clause, the deed should be construed according to the special matter. The case may, however, be taken out of its operation by the evident intent of the parties and the clearly expressed purpose of the deed. Thus, where the instrument under consideration is a general assignment of all the property and effects of the assignor, and the intent to place all the property of every description within the trust is apparent in every part of the deed, although it contain a reference to a schedule of the assigned effects as annexed, this will not be construed as indicating an intention to qualify or limit the comprehensive or general language, and property not mentioned in the schedule will pass to the trustee. SS 344. Explaining obnoxious provisions. When it is shown that the obnoxious provisions of the deed were not made deliberately, understandingly, or even knowingly, then the law's presumption of the intent to defraud is rebutted. The reason ceasing the rule ceases. In an inquiry collateral to the deed, it is competent to show by parole that the deed was made in its objectionable form by the mistake of the scrivener, and without the intention and knowledge of the parties to it. And so to rebut the presumption of fraud, SS 345, assignments held void, it would be an arduous task to collate and cite the numerous cases in which assignments have been overturned at the instigation of creditors. The important features of the law will, however, be noticed. The instrument was avoided where it provided that the debtor shall have the privilege of continuing his business for 1 year. In fact, any reservation of benefit to the grantor is considered fatal, stipulating for possession of the assigned property, and providing for the payment of individual debts out of copartnership assets, are additional illustrations of obnoxious provisions which will annul the instrument. So, as we have seen, the instrument is rendered void by intentional omissions of assets, and the insertion of fictitious liabilities. The insertion of a provision for the employment of the assignors furnishes some evidence of fraudulent intent. The insertion of a provision for the employment of the assignors furnishes some evidence of fraudulent intent. SS 346. Foreign assignments. The rule generally obtains that the statute laws of a particular state regulating assignments for the benefit of creditors do not apply to foreign assignments. Such transfers, if valid by the law of the place where made, are valid everywhere, and will protect the property from attachment, except perhaps as regards creditors who are residents of the particular state in which it is sought to enforce the provisions of the instrument, as the foreign assignment is allowed to operate as a matter of comity. The courts sometimes refuse to enforce it to the prejudice of their own citizens. Manifestly, an assignment will not take effect to pass title to personal property situate in another state in express contravention of the statute law of that state. The distinction should not be overlooked between assignments by act of the party and those by operation of law. The latter class of conveyances are generally founded upon statutory provisions and have no extraterritorial force. This, however, is a line of inquiry foreign to our subject. SS 346A. Assignments by corporations. Where charter restrictions or statutory inhibitions do not exist, a corporation may make a general assignment. Such a transfer is, however, prohibited by statute in New York and some other states. Where assignments by corporations are allowed, they are subject to attack upon substantially the same grounds as in the cases of similar transfers by individuals.